Welcome everybody. You're very welcome on this Thursday afternoon. Um, just as people are joining, we're just going to give a minute before we actually start the webinar, but everybody is really welcome. And I suppose just to let everybody know that this webinar will be recorded and as always will be available on our website and the Legal Aid Board website as well. And we will put links up at the end of the webinar to all our previous webinars and recordings that we've done with the Legal Aid Board as well. You're all very welcome. And I'm just seeing if there's a few more people joining. Perfect. I think everybody's nearly in now. So just for those of you who don't know me, my name is Niamh McCarthy. I am the manager of the Bernardo's Parental Advocacy Service, which supports parents of children in care and supports them with court attendance or in supports with meetings with tools or access to information. And these webinars are part of our information and advice service, which is a national service, and it's about taking certain topics, and we're looking at having a clear discussion about what that looks like from a parent's perspective as well. I'm joined today by Stephen Cahill, who is the managing solicitor in Chancery Street, and Stephen has been really generous with his time and joins us most Thursdays now to give us his insight on the various topics. At the end of the webinar will be a feedback sheet, so please feel free to use that sheet to give us we're not precious about these, so anything that you feel could have been done better or any suggested topics or answer, please let us know. We welcome all feedback. And please feel free to use the chat as well and put any questions you have to either myself or Stephen. And I've gathered a number of questions from parents that work with our service or who have given us feedback that I'm going to put to Stephen today. So, the topic of today's webinar is looking at access, and I suppose specifically access orders in terms of Stephen's professional experience. But I suppose, Stephen, we kind of just the starting point that we find a lot of parents will often ask us, an interim care order has been granted. Is access automatically part or of that order? Is there a specific section that deals with access in that order?
Yeah. So Section 37 of the Childcare Act governs access to and for children in care. The starting position is that if a child is received into care, Section 37 applies automatically.
Okay.
And what Section 37 says is that the Child and Family Agency shall provide reasonable access for the child to their parent or any other person with a bona fide interest in that child. So the starting position is the agency have to provide and facilitate reasonable access. It will then fall to, I suppose, the agency to determine what actually is the reasonable amount. But the starting position is they have to provide access.
Okay, great. So I'm a parent in that situation, and unfortunately, my children have gone into the care of Tulsa, and I've been provided with supervised access maybe once every 2 weeks, or for some children, and once a week for other children. I'm really unhappy with that. What I've raised it with the children's social workers, and I've completed an access review with Tulsa. We've sat down, we've looked at it. It may be that there's a resource issue, the access needs to be supervised, and there's not enough availability for that to take place. What are my options in that case?
So any party, any person who is dissatisfied with the level of access being provided can bring an application to court under Section 37 to seek specific access orders. So if you're unhappy with the frequency of access, so how often it takes place, if you're unhappy with how long the access is being scheduled for, or if you're unhappy with the other arrangements, such as where the access is taking place, if it's being supervised and you're dissatisfied, you can bring an application to court and look for a specific order, a specific direction that access takes place in a specific manner, at a specific frequency or duration. So if you are dissatisfied with access that is being provided to you, you can bring that application to court and seek a specific order.
Okay, and so that would be a separate hearing then, would it, Stephen?
So you can bring an access application on 2 days' notice to the district court. Ordinarily, you might return that application to the same date as, say, the interim care order is up for renewal or extension. But if, for example, you're in court and an interim care order is extended for 28 days, you don't necessarily have to wait for 4 weeks to bring your access application. In theory, you can bring it at any stage once you give the 2 days notice.
Okay. And once I bring that, or say that's the route that I feel is best for my family, and I'm deciding to do that, um, would I presume the social workers will be asked to give evidence as to why the access arrangements are in their current form? Would the child's guardian ad litem be requested to attend that hearing as well? And what would be the burden on the parent to increase access?
So if you are bringing the application to court, you are the applicant. So it'll be different to how the ordinary applications, so interim care orders and extensions run. That's where the Child and Family Agency bring the case and they present their case. This is an application brought by the parent. So even just to bring it to court, a parent will need to set out on affidavit the grounds, why what they say that the arrangements are and what they're looking for, what they think is reasonable. So in advance of the matter going to court and being filed in court, the parents will have set out on affidavit what it is they're looking for. That then will be served on the other parties and will be filed in court. So the judge will, in advance of your application, be on notice of what it is you're looking for. So as the applicant, so it's your application, the parent has the opportunity to give the evidence first. So they can get into the witness box and speak to the judge, and they can set out for the judge, what it is they're looking for and why they're looking for certain access arrangements, why they think it's in their child's best interest. The Child and Family Agency will also have prepared a report setting out their position, and the guardian ad litem will also set out in a report their position. And then it's a matter for the court to hear the evidence and determine one way or the other if your application is successful or otherwise.
Okay, and just going back a few steps, Stephen. So the first step is to set out the reasons and complete an affidavit. So who would the parent do that with?
Sure. So I think that's very sensible. Take a step back. So even before we would advise a parent to bring an application to court just on access, we would suggest going through a few certain steps in advance. So firstly, that you would ask for an access review to take place, where you have the opportunity to sit down with the social workers, and if you have a support person or an advocate with you, all the better. Also with maybe the guardian ad litem to discuss and review access, and then you can put your proposals forward at that stage outside of court. And if you get an access plan that you're happy with, then great, you don't need to bring your application to court. But if you're not satisfied with the arrangements after that, then it's appropriate to issue your application.
Yes, yeah. And I suppose for many parents, sometimes the access plan is working really well, and then something may change for a placement may change for a child, and the access plan has to change with that. And then does that automatically need to be reviewed once placements change, or is there anything that triggers automatic reviews for access?
So the agency will often assert that access is always the subject of an ongoing review, that they will consider day-to-day changes in circumstances as part of their overall assessment of access and what arrangements they're going to put in place. If there is a very significant event or change of circumstances, such as a change of placement, I think it's appropriate for the agency to have an immediate access review, certainly to involve the parent and to see what arrangements can be put in place that will work best for the parent and also obviously for the child as well.
Yeah, yeah. And what if what about grandparents and siblings if they want to have more family contact? Is it then seen, can they go in under Section 37 of the Childcare Act, or is it a private family matter?
So Section 37 says any person who's dissatisfied with the arrangements can bring an application to court. And that any person is typically a grandparent, an aunt, an uncle who who feels that their contact with a child who's in the care of the agency isn't being promoted or maintained as they feel it should be. So any party can bring that application to court. And again, that party would be best advised to, ask to meet with the social workers in the first instance to discuss access, to put forward their proposals and arrangements. And if they're not agreed to by the Child and Family Agency, then to speak to a solicitor and discuss potentially bringing an application to court, drafting your affidavits, filing it in court, serving it, and getting your court date.
Okay, and I'd say that's probably similar for arrangements. So while there's many formal care arrangements in place, for some families there is informal private arrangements with kinship or relative carers, and sometimes TULSA or the Child and Family Agency may close the case, and but they may have had some oversight and some recommendations around family contact, and now it's up to both family members to arrange that, and that can sometimes be very difficult for the parent and difficult for the foster parent as well, or the relative carer as well. And um we have, I think there's a few options, but I'd be interested in your view. In those instances, we have recommended the use of the family mediation service by the Legal Aid Board, or they possibly could look to seek an access order as well.
Yeah. So if a child is in an alternative care arrangement, such as a private family arrangement, but isn't in the care of the Child and Family Agency, then the Childcare Act and Section 37 doesn't apply.
Yeah.
So it's private law. So ideally, this private arrangement can be worked out amongst the parties themselves between the various family members. But in the event that agreement can't be reached, then there may have to be recourse to the private family law courts. But again, so similar to the advice we'd give around bringing a childcare application, before you go to court, you'd see, can you have a meeting and resolve things? Would give the same advice to someone in a private family arrangement. And as you've mentioned there, the family mediation service is a fantastic free service that's available there to help parties mediate what can be very difficult, complex arrangements and avoid the need to actually go to court.
Yeah. And just going back to as well, Stephen, sibling family contact or sibling access, like, is that automatically something that is discussed as part of the interim care order, or is that um, left up to the agency to decide what is in the best interest of the siblings? And I suppose it's really a key area, I suppose, if there had been a number of siblings, say in a family four, and if they've all gone into care, but maybe different placements, so they're all separated from each other as well, it can be a really difficult time for young people and children in care.
Yeah, so in considering any application to do with the child in care, so an application to extend an interim care order, for example, the court will want to look at the child's circumstances and all of the parts of that child's, welfare interest. And a big part of that is the child's contact with not only their parents, but also with any siblings. So, that will be part of the court's consideration. We'll look at what contact is the child having with their siblings. So if the siblings are in different placements, the starting position is, and the presumption is that access and contact with your siblings is in your best interest. And if it's not being facilitated by the Child and Family Agency, the court will likely intervene and would perhaps make directions, even off its own bat, that such sibling access would be promoted. And I would expect any child's guardian ad litem as well to be advocating for increased contact with their siblings if it's deemed insufficient.
Yeah. So it's very important for the parent to give their own solicitor and the guardian ad litem and the social workers such a really good oversight of what their family life was like the strengths within it as well, and the relationships between the siblings and extended family members, I suppose, at those early stages of children going into care as well, who are the significant people in the child's life. Um, Sorry.
Yeah, I think that's hugely important. So if a child, is removed from the care of their parents and goes into care, that's a huge obviously disruption for them and a massive change in their circumstances. And anything that can give them an ongoing sense of continuity is clearly in the best interest. So, to have continued ongoing contact with their siblings is obviously going to be in their best interest. Um, in all but exceptional cases.
Yeah. One of the things that has come up a lot, Stephen, is where there's very complex cases where there may be private family arrangements for some of the children, and ongoing then private law proceedings around that child, for example. Whereas then there may be interim care order hearings going on for, say, three other children or four other children in the same family, and there may be different judges sitting on these cases as well. Is there any interaction between those cases, or do I suppose if one recommendation is given in relation to the private arrangement in terms of access, would that feed into then the childcare proceedings or vice versa?
So the starting point would be that the cases would be separate and distinct. So where you have public law proceedings, as in where the Child and Family Agency are the applicant, and where you have private family law proceedings, they are separate and distinct. And in Dublin, they wouldn't even be heard in the same
Yeah.
courthouse. In Dublin, the private law would be in Dolphin House, and the public law would be in Chancery Street. It is a difficulty even that TUSLA encounter where they have a child in their care, and even where TUSLA actually want to promote contact with that child's siblings, where the siblings aren't in care. It's very difficult. TUSLA can't compel the parties looking after those other children to abide by and agree to whatever arrangements TUSLA wish to put in place. So yeah,
Yeah.
there's a lot of complicating factors.
Yeah, it is a very complicated area, isn't it, as well? And I suppose the other thing is about, from a practice point of view and things, family contact or access is very alien for child and parent, and it's supervised. And I suppose, is there any criteria or, I suppose, checklist that the judges or the Child and Family Agency would look at to see where it should be stopped or where it should be increased, or is it based on all individual circumstances?
Yeah, I think it is based on all individual circumstances. No two cases and no two children's relationships with their parents are going to be the same.
Yeah, yeah, because and that's the way it should be, really, isn't it? Because it is such a unique relationship for every child, even within the same families.
Yeah, and I think the once a child has been received into care, the usual starting point would be that the initial access visits would be in a TUSLA venue and would be supervised by a TUSLA staff member. And that can be very, very difficult for a parent to adjust to having, maybe just gone from having this child full time in their care to now only having limited contact in a supervised setting. So that can be very difficult. One way I try and ask a parent to consider to look at supervised contact is almost to demonstrate that supervised contact is not necessary. That, the contact in the first instance is the most important thing, and thereafter to worry about, allowing TUSLA to pull back. Ideally, it's to go in with that kind of a mindset rather than, feeling undermined or criticized or felt, you know, again, criticized or that there's a real need for supervision where that may not be accepted by a parent.
Yeah, yeah. And it is so difficult because it's such a, and children can become very dysregulated at the end, and parents are as well. Um, the other main question that was coming up as well, and we have something in the chat that I'll come to now, is a lot of parents have raised that when a full care order is granted, automatically then their family contact or their access is reduced significantly, possibly to once a month. There's no longer supports in attending access. And is that a standard practice and many parents report regardless of the quality of the access, like it may be going really well, but because the order has been granted, it's automatically cut to once a month.
I think that is an unfortunate reality that has been the experience, is the experience of many parents, that if a care order is granted, that all of a sudden they do find their access being reduced. But I'd say that this, it kind of underscores the importance of, at the care order hearing, thrashing out the issue of access and securing commitments that
Okay.
would continue at a certain frequency and in fact would be reviewed on an ongoing basis with a view to increasing it. Because the legal position is, even if there's a long-term care order in place, there's still an ongoing obligation on the agency to build and repair relationships as much as possible. I don't think it's really acceptable for the agency, once a care order is in place, to then say access is now actually only about maintaining your sense of identity with the parent. It should be much more than that. And I think any parent who's faced with what they feel is an unfair reduction in access, that they should really go and to talk to a solicitor and take advices on it.
Great. Thanks, Stephen. And just in the chat here, the question is there anybody that provides mediation service to parents in childcare proceedings for both Child and Family Agency and the parents to attend?
So there certainly are some private services, but also the family mediation service attached with the legal aid board. A difficulty is actually procuring the agency's buy-in to mediation. I find that quite often they wouldn't necessarily be open to it. They'll say that they're open to, engaging with parents, and there's no difficulty with that, but don't see the need for mediation. So that can be a fundamental difficulty to getting mediation off the ground where the agency are involved.
Yeah, yeah. And I think, again, it's back to those individual cases and the individual circumstances, and where possible, to try and bring those suggestions forward if communication is breaking down, and if it is difficult, to ask for a communication review or what supports we can put in place to look at it, and mediation being an option there. Our final question today, Stephen, is around, I suppose, newborn babies and access. And again, it's, is there a standard? What some parents will report that they get once their baby is born, particularly if they're breastfeeding in the mother's case, or that, or if the baby for some reason is premature, that, or is in the hospital for an extended period of time, that they will have access on a daily basis, particularly if the baby is in hospital and the parents are with the baby for extended times. And as time goes on, then in the next, over the next month or two, that is then reduced significantly as well. And in other cases, that parents report they are breastfeeding, but they only get to see their child once a week, and they are making arrangements for breast milk to be delivered or stored. But I suppose, is there any standard practice or standard guidelines around newborn babies going into care, and the level of family contact or parental contact there should be?
So the starting point, I suppose, in order for a newborn to be brought into the care of the Child and Family Agency, the law is quite clear, is that it's a particularly high threshold that has to be met, given just how draconian and how serious an order taking a newborn into care is. So it's a very high bar that the agency must prove in court for an order to be made. But even if that order is made, again, appreciating again the fundamental importance of the bonding, and particularly in the very early stages, the usual operation around access is that it would be very, very frequent, if not daily. So if the child is being maintained in the hospital, it's hard to see how or why a parent would be denied access if it can be facilitated safely in a hospital. So that is the starting point. Then, obviously, if a parent is choosing to breastfeed, that would be facilitated as much as possible, particularly at the beginning. But even if direct breastfeeding isn't going to be facilitated, appropriate arrangements do need to be put in place, whatever that may be.
Yeah, yeah. Thanks so much, Stephen, for today. Those half hours really fly by, and I suppose we could talk about these topics all day, but I'm sure there's more questions that come to people's minds. So again, I just like to remind people to please feel free to use the feedback form, and if there's any questions or any clarity you need, please do come back to us as well. We are going to put up those slides now, so I thank Stephen for his time today. And next week, we will be looking at a very specific area, which is special care orders. So that'll be next Thursday at the same time as well. So thank you. And Sylvia is just going to share the slide now with the QR codes for our previous webinars, our websites, if you need any information. We have free phone numbers up there as well, and our feedback form as well. So please feel free to use them. And thank you so much for coming on, and all of your questions as well. And please feel free to keep sending them in as well. And I look forward to seeing you next Thursday. Thank you.